भारत का संविधान पार्ट 13 ट्रेड कॉमर्स एंड इंटरकोर्स विदिन द टेरिटरी ऑफ इंडिया आर्टिकल 301 freedom of trade commerce and intercourse subject to the other provisions of this part. Trade commerce and intercourse throughout the territory of India shall be free. 302 power of parliament to impose restriction on trade commerce and intercourse. Parliament may by law impose such restriction on the freedom of trade commerce or intercourse between one state and another or within any part of the territory of India as may be required in the public interest. Article 303 restriction on the legislative power of the union and the states with regard to trade and commerce. 1. Notwithstanding anything in Article 302, neither Parliament nor the legislature of a state shall have power to make any law giving or authorizing the giving of any preference to one state over another or making or authorizing to making of any discrimination between one state and another by virtue of any entry relating to trade and commerce in any of the list of the 7 scheduled. 2. Nothing in clause A shall prevent Parliament for making any law giving or authorizing the giving of any preference for making or authorizing the making of any discrimination if it is declared by such law that it is necessary to do so for the purpose of dealing with a situation arising from scarcity of goods in any part of the territory of India. Article 304 restriction on trade, commerce and intercourse among states. Notwithstanding anything in the Article 301 or Article 303, the legislature of a state may by law impose one goods imposed from other state or the union territories, any tax to which similar goods manufactured or produced in that state are subject, so however as not to discriminate between goods so imported and goods so manufactured or produced, and B. impose such reasonable restriction on the freedom of trade, commerce or intercourse with or within the state as may be required in the public interest. Provided that no bill or amendment for the purpose of clause B shall be introduced or moved in the legislature of a state without the previous sanction of a president. Article 305 saving of existing laws and laws prevailing for state monopolies. Nothing in Article 301 and 303 shall affect the provisions of any existing law except in so far as the President may by order otherwise direct, and nothing in Article 301 shall affect the operation of any law made before the commencement of the Constitution, Fourth Amendment Act 1955, insofar as it relates to or prevent Parliament or legislature of a state for making any law relating to any such matter as is referred to in subclause 2 of clause 6 of Article 19. 306. Power of certain state in Part B of the first schedule to impose restriction on trade and commerce. REP by the Constitution 7th Amendment Act 1956, Section 29 and SCH. Article 307. Appointment of authority for carrying out the purposes of Article 301 to 304. Parliament may by law appoint such authority as it considered appropriate for carrying out the purpose of Articles 301, 302, 303 and 304 and confer on the authority so appointed such powers and such duties as it thinks necessary. Part 14. Services under the Union and the States. Chapter 1. Services. Article 308. Interpretation. In this part, unless the context otherwise require, the expression state does not include the state of Jammu and Kashmir. Article 309. Recruitment and conditions of service of persons serving the union or a state. Subject to the provisions of this Constitution, acts of the appropriate legislature may regulate the recruitment and condition of service of persons appointed to public services and post in connection with the affairs of the union or any state, provided that it shall be competent for the president or such person as he may direct in the case of services and post in connection with the affairs of the union and the governor of a state or such person as he may direct in the case of services and post in connection with the affairs of the state, to make rules regulating and recruitment and the condition of service of persons appointed to such services and post until provisions in that behalf is made by or under an act of the appropriate legislature. Under this article, and any rules so made shall have effect subject to the provisions of any such act. Article 310. Tenure of office of persons serving the union or a state. 1. Except as expressly provided by the Constitution, every person who is a member of a defence service or of a civil service of the Union or of All India Service or holds any post connected with the defence or any civil post under the Union hold office during the pleasure of the President, and every person who is a member of a civil service of a state or holds any civil post under state holds office during the pleasure of the governor of the state. 2. Notwithstanding that a person holding a civil post under the union or a state holds office during the pleasure of the president or, as the case may be, the governor of the state, any contract under which a person not being a member of a defense service or of an all India service or of a civil service of the union or a state is appointed under this constitution to hold such post may, if the president or the governor, as the case may be, deems it necessary in order to secure the services of persons having special qualifications, provide for the payment to him for compensation if before the expiration of an agreed period that post is abolished or he is or regions not connected with any misconduct or on his part required to vacate the post. Article 311 Dismissal, removal or reduction in rank of persons employed in civil capacity under the union or a state. 1. No person who is a member of civil service of the union or an all India service or a civil service of a state or holds a civil post under the union or a state shall be dismissed or removed by an authority subordinate to that by which he was appointed. 2. No such person as aforesaid shall be dismissed or removed or reduced in rank except after an inquiry in which he has been informed of the charges against him and given a reasonable opportunity of being heard in respect of those charges, provided that where it is proposed after such inquiry to impose upon him any such penalty may be imposed on the basis of the evidence adduced during such inquiry, and it shall not be necessary to give such person any opportunity to making representation on the penalty proposed. Provided further that this clause shall not apply a. Where a person is dismissed or removed or reduced in rank on the ground of conduct which has led to his conviction on a criminal charge, or b. Where the authority empowered to dismiss or remove a person or to reduce him in rank is satisfied that for some reason to be recorded by that authority in writing, it is not reasonably practicable to hold such inquiry, or c. Where the president or the governor, as the case may be, is satisfied that in the interest of the security of the state it is not expedient to hold such inquiry. 3. If in respect of any such person as aforesaid questions arise whether it is reasonably practicable to hold such inquiry as is referred to in clause 2, the decision thereon of the authority empowered to dismiss or remove such person or to reduce him in rank shall be final. Article 312 All India Services. 1. Notwithstanding anything in chapter 6 or part 6 or part 11, if the Council of State has declared by resolution supported by not less than 2/3 of the members present and voting that it is necessary for expedient in that national interest so to do, Parliament may by law provide for the creation of one or more All India services, including an All India Judicial Service, common to the Union and the states, and subject to the other provisions of the chapter, regulate the recruitment and the condition of service of persons appointed to any such service. 2. The service known at the commencement of this constitution as the Indian Administrative Service and the Indian Police Service shall be deemed to be service created by Parliament under this article. 3. The All India Judicial Service referred to in clause 1 shall not include any post inferior to that of a district judge as defined in Article 236. 4. The law prevailing for the creation of the All India Judicial Service aforesaid may contain such provisions for the amendment of Chapter 6 and Part 6 as may be necessary for giving effect to the provisions of that law, and no such law shall be deemed to be an amendment of this constitution for the purpose of Article 368. Article 312A. Power of Parliament to vary or revoke condition of service of officers in certain services. 1. Parliament may by law A. Vary or revoke whether prospectively or retrospectively the condition of services as respects remuneration, leave and pension, and the right as respect disciplinary matter of persons who, having been appointed by the Secretary of State or Secretary of State in Council to a civil service of the Crown in India before the commencement of this constitution, continue on and after the commencement of the constitution. 28 Amendment Act 1972 to serve under the Government of India or of the state in any service or post. B. Vary or revoke whether prospectively or retrospectively the condition of service as respects pensions of persons who, having been appointed by the Secretary of State or Secretary the State in Council to a civil service of the Crown in India before the commencement of this constitution, retired or otherwise, cease to be in service at any time before the commencement of the constitution. 28 Amendment Act 1972. Provided that in the case of any such person who is holding or has held the office of the Chief Justice or other judge of the Supreme Court or a High Court, the Comptroller and Auditor General of India, the Chairman or other member of the Union or a State Public Service Commission or a Chief Election Commissioner, and nothing in subclauses A or subclauses B shall be construed as empowering Parliament to vary or revoke after his appointment to such post the condition of his service to his disadvantage, except in so far as such condition of service are applicable to him by reason of his being a person appointed by a Secretary of State or Secretary of State in Council to a civil service of the Crown in India. 2. Except to the extent provided for by Parliament by law under this article, nothing in this article shall affect the power of any legislature or other authority under any other provisions of the Constitution to regulate the conditions of service of person referred to in clause 1. 3. Neither the Supreme Court nor any other court shall have jurisdiction in a. Any dispute arising out of any provisions of or any endorsement on any convent agreement or other similar instrument which was entered into or executed by any person referred to in clause 1 or arising out of any letter issued to such person in relation to his appointment to any civil service of the crown in India or his continues in service under the government of the dominion of India or a province thereof. B. Any dispute in respect of any right, liability or obligation under Article 314 is originally enacted. 4. The provisions of this article shall have effect notwithstanding anything in Article 314 as originally enacted or in any other provisions of the Constitution. Article 313. Transitional provisions. Until other provisions is made in this behalf under the Constitution, all the laws in force immediately before the commencement of the Constitution and applicable to any public service or any post which continues to exist after the commencement of this Constitution as an all India service or as service or post under the union or state shall continue in force so far as consistent with the provisions of this Constitution. Article 314. Provision for protection of existing officer of certain service REP by the Constitution 28 Amendment Act 1972 Section 3 with effect from 29 August 1972. Chapter 2 Public Service Commissions. Article 315 Public Service Commissions for the Union and for the States. 1. Subject to the provisions of this chapter, there shall be a Public Service Commission for the Union and the Public Service Commission for each state. 2. Two or more states may agree that there shall be one Public Service Commission for that group of states, and if a resolution to that effect is passed by the House, or where there are two houses, by such house of a legislature of each of these states, Parliament may by law provide for the appointment of a joint state Public Service Commission referred to in this chapter as Joint Commission to serve the need of those states. 3. Any such law as aforesaid may contain such incidental and consequential provisions as may be necessary or desirable for giving effect to the purpose of the law. 4. The Public Service Commission for the Union, if required so to do by the Governor of a state, may, with the approval of the President, agree to serve all or any of the needs of the state. 5. Reference in this Constitution to the Union Public Service Commission or a State Public Service Commission shall, unless the context otherwise requires, be construed as a reference to the Commission saving the needs of the Union, or as the case may be, the state as respects the particular matter in the questions. Article 316. A appointment and term of office of members. 1. The chairman and other members of a public service commission shall be appointed in the case of the union commission or a joint commission by the president, and in case of state commission by the governor of the state, provided that as nearly as may be one half of the members of every public service commission shall be persons who at the dates of their respective appointments have hold office for at least 10 years either under the government of India or under the government of a state, and in computing the said period of 10 years, any period before the commencement of this constitution during which a person has hold office under the crown in India or under the government of an Indian state shall be included. 1A. If the office of the chairman of the commission becomes vacant, or if any such chairman is by reason of absence or for any other reason unable to perform the duties of his office, those duties shall until some person appointed under clause 1 to the vacant office has entered on the duties thereof, or as the case may be, until the chairman has resumed his duties, be performed by such one of the other members of the commission as the president. In the case of union commission or a joint commission, and the governor of the state, in the case of the state commission, may appoint for the purpose. 2. A member of a public service commission shall hold office for a term of 6 years for the date on which he enters upon his office, or until he attains, in the case of union commission, the age of 65 years, and in the case of state commission or a joint commission, the age of 62 years, whichever is earlier. Provided that a member of a public service commission may, by writing under his hand addressed in the case of the union commission or a joint commission to the president, and in the case of a state commission to the governor of the state, resign his office. B. A member of public service commission may be removed from his office in the manner provided in clauses 1 or clauses 3 of the article 317. 3. A person who holds office as a member of a public service commission shall, on the expiration of his term of office, be ineligible for appointment to that office. Article 317. Removal and suspension of a member of a public service commission. 1. Subject to the provisions in clause 3, the chairperson or any other member of the public service commission shall only be removed from his office by order of president on the ground of misbehavior after the Supreme Court, on reference being made to it by the president, has on inquiry held in accordance with the procedure prescribed in that behalf under Article 145, reported that the chairman or such other member, as the case may be, ought on any such ground to be removed. 2. the president in the case of the union commission or a joint commission, and the governor in the case of a state commission may suspend from office the chairman or any other member of the commission in respect of whom a reference has been made to the Supreme Court under clause 1 until the president has passed orders on receipt of the report of the Supreme Court on such reference. 3. Notwithstanding anything in clause 1, the president may by order remove from office the chairman or any other member of the Public Service Commission if the chairman or such other member, as the case may be, A. is adjudged insolvent, or B. engages during his term of office in any paid employment outside the duties of his office, or C. is, in the opinion of the president, unfit to continue in office by reason of infirmity of mind or body. 4. If the chairman or any other member of a public service commission is or becomes in any way concerned or interest in any contract or agreement made by or on behalf of the government of India or the government of the state, or participates in any way in the profit thereof or in any behalf or emolument arising therefrom otherwise than as a member and in common with the other members of an incorporated company, he shall, for the purpose of clause A, be deemed to be guilty of misbehavior. Article 318, power to make regulation as to condition of service of members and staff of the commission. In the case of a union commission or a joint commission, the president, and in the case of a state commission, the governor of a state may by regulations A. determine the number of members of the commission and their conditions of service, and B. make provisions with respect to a number of members of the staff of the commission and their condition of service, provided that the condition of service of the member of a public service commission shall not be varied to his disadvantage after his appointment. Article 319, prohibition as to the holding of offices by members of commission on ceasing to be such members on ceasing to hold office. A. The chairman of the Union Public Service Commission shall be ineligible for further employment either under the Government of India or under the Government of a state. B. The chairman of a state public service commission shall be eligible for appointment as the chairman or any other member of the public service commission or as the chairman of any other state public service commission, but not for any other employment either under the Government of India or under the Government of a state. C. A member other than the chairman of the Union Public Service Commission shall be eligible for appointment as the chairman of the Union Public Service Commission or as the chairman of a state public service commission, but not for any other employment either under the Government of India or under the Government of a state. D. A member other than the chairman of a state public service commission shall be eligible for appointment as the chairman or any other member of the Union Public Service Commission or as the chairman of that or any other state public service commission, but not for any other employment either under the government of India or under the government of a state. Article 320, Functions of Public Service Commissions. 1. It shall be the duty of Union and the State Public Service Commissions to conduct examination for appointments to the services of the Union and the services of the State respectively. 2. It shall also be the duty of the Union Service Commission, if requested by any two or more states so to do. It assists those states in framing and operating schemes of joint recruitment for any services for which conditions candidates possessing special qualifications are required. 3. The Union Public Service Commission or a State's Public Service Commission, as the case may be, shall be consulted a. on all matters relating to method of recruitment to civil service and for civil posts. B. On the principles to be followed in making appointments to the civil service and post and in making promotion and transfers from one service to another, and on the suitability of conditions for such appointment, promotions and transfers. C. On all disciplinary matters affecting a person's serving under the government of India or the government of a state in a civil capacity, including memorials or petitions relating to such matters. D. On any claim by or in respect of a person who is serving or has served under the government of India or the government of a state or under the crown in India or under the government of an Indian state in a civil capacity, that any cost incurred by him in defending legal proceedings instituted against him in respect of acts done or purporting to be done in the execution of his duty should be paid out of the consolidated fund of India, or as the case may be, but of the consolidated fund of the state. E. On any claim for the award of a pension in respect of injuries sustained by a person while serving under the government of India or a government of a state or under the crown in India or under the government of an Indian state in civil capacity, and any questions as to the amount of any such award. And it shall be the duty of Public Service Commission to advise on any matter so referred to them and on any other matter which the President or as the case may be, the Governor of the state may refer to them, provided that the President as respects the All India services and also as respects other services and post in connection with the affairs of the Union, and the Governor as respects other services and post in connection with the affairs of a state, may make regulation specifying the matters in which either generally or in any particular class or case or in any particular circumstances, it shall not be necessary for the Public Service Commission to be consulted. A. Nothing in clause 3 shall require a Public Service Commission to be consulted as respects the manner in which any provisions referred to in clause 4 of Article 16 may be made, or as respects the manner in which effect may be given to the provisions of Article 335. 5. All regulation made under the provisions proviso to clause 3 by the President or the Governor of a state shall be laid for not less than 14 days before such House of Parliament or House or each House of the Legislature of the state, as the case may be, as soon as possible after they are made, and shall be subject to such modification, whether by way of repeal or amendment. So both Houses of Parliament or the House or both Houses of the Legislature of the state may make during the session in which they are so laid. Article 321. Power to action functions of Public Service Commissions. An act made by the Parliament or, as the case may be, the legislature of a state may provide for the exercise of additional functions by the Union Public Service Commission or the Public Service Commission as respects the services of the Union or the state, also as respect the services of any local authority or other body corporate constituted by law or any public institution. Article 322. Expenses of Public Service Commissions. The expenses of the Union or a State Public Service Commission, including any salaries, allowances and pensions payable to or in respect of the members or staff of the commissions, and shall be charged on the Consolidated Fund of India or, as the case may be, the Consolidated Fund of the state. Article 323. Reports of Public Service Commission. 1. It shall be the duty of Union Commission to present annually to the President or report as the work done by the Commission, and on receipt of such reports the President shall cause a copy thereof together with the memorandum explaining as respect the cases, if any, where the advice of the Commission was not accepted, the reasons for such non-acceptance to be laid before each House of Parliament. 2. It shall be the duty of a State Commission to present annually to the Governor of the state or state a report as to the work done by the Commission, and it shall be the duty of Joint Commission to present annually to the Governor of each of the states the needs of which are served by the Joint Commission. A. Report as to the work done by the Commission in relation to the state, and in either case the Governor shall, on receipt of such report, cause a copy thereof together with memorandum explaining as respects the case, if any, where the advice of the Commission was not accepted, the reason for such non-acceptance to be laid before the legislature of a state. The Constitution of India, Part 14A, Tribunals. Article 323A, Administrative Tribunals. 1. Parliament may, by law, provide for the adjudication or trial by administrative tribunals of disputes and complaints with respect to recruitment and condition of services of persons appointed to public services and post in connection with the affairs of the union or of any state or of any local or other authority within the territory of India or under the control of the government of India or of any corporation owned or controlled by the government. 2. A law made under clause 1 may a. provide for establishment of an administrative tribunal for the union and a separate administrative tribunal for each state for two or more states. B. Specify the jurisdiction's powers, including the power to punish from contempt and authority which may be exercised by each of the said tribunals. C. Provide for the procedure, including provisions as to limitation and rules of evidence to be followed by the said tribunals. B. D. Exclude the jurisdiction of all courts except the jurisdiction of the Supreme Court under Article 136 with respect to the disputes or complaints referred to in clause 1. E. Provide for the transfer of each such administrative tribunals of any cases pending before any courts or other authority immediately before the establishment of such tribunals as would have been within the jurisdiction of such tribunal if the cause of action on which such suits or proceedings are based had arisen after such establishment. F. Repeal or amend any order made by the President under clause 3 of Article 371D. G. Contain such supplemental, incidental, consequential provisions, including provisions as to fees as Parliament may deem necessary for the effective functioning of and for the speedy disposal of cases by and the enforcement of the orders of such tribunals. 3. The provisions of this article shall have effect notwithstanding anything in any other provisions of this constitution or in any other law for the time being in force. Article 323B. Tribunals for the other matters. Article 323B. Tribunals for the other matters. 1. Appropriate legislature may, by law, provide it for the adjudication or trial by tribunals of an disputes, complaints or offices with respect to all or any of the matters specified in clause 2 with respect to which such legislature has power to make laws. 2. The matters referred to in clause 1 are the following, namely: A. Levy, assessment, collection and enforcement of any tax. B. Foreign exchange, import and export across customs frontiers. C. Industrial and labor disputes. D. Land reforms by way of acquisition by the state of any state as defined in Article 31A or of any rights therein, or the extinguishment or modification of any such rights, or by way of sealing on agricultural land or in any other way. E. Sealing on urban property. F. election to either house of parliament or either house of legislature of a state, but excluding the matters referred to in Article 329 and Article 329A. G. Production, procurement, supply and distribution of food stuff, including edible oil seed and oils and such other goods as the President may, by public notification, declare to be essential goods for the purpose of this article and control of prices of such goods. H. Rent, its regulation and control and tenancy issues, including the right, title and interest of landlords and tenants. I. Offense against law with respect to any of the matters specified in subclauses A to H, and fees in respect of any of those matters. J. Any matter incidental to any of the matters specified in subclause A to I. 3. A law made under clause 1 may A. Provide for the establishment of a hierarchy of tribunals. B. Specify the jurisdiction's powers, including the power to punish for contempt and authority which may be exercised by each of the said tribunals. C. Provide for the procedure, including provisions as to limitation and rules of evidence to be followed by the said tribunals. D. Exclude the jurisdiction of all courts except the jurisdiction of the Supreme Court under Article 136 with respect to all or any of the matters falling within the jurisdiction of the said tribunals. E. Provide for the transfer of each such tribunals of any cases pending before any court or any other authority immediately before the establishment of such tribunals as would have been within the jurisdiction of such tribunals if the causes of action on which such suits or proceedings are based had arisen after such establishment. F. Contains such supplemental, incidental and consequential provisions, including provisions as to fees as to appropriate legislature may deem necessary for the effective functioning of and for the speedy disposal of cases by and the enforcement of the orders of such tribunals. 4. The provisions of this article shall have effect notwithstanding anything in any other provisions of this Constitution or in any other law for the time being in force. Explanation. In this article, appropriate legislature in relation to any matter means Parliament or, as the case may be, the state legislature competent to make laws with respect to such matters in accordance with the provisions of Part 11, Part 15, Elections. The Constitution of India, Part 15, Elections, Article 324, Superintendence, Direction and Control of Elections to be vested in an Election Commission. 1. The Superintendence, Direction and Control of the preparation of the electoral roll for and the conduct of all elections to Parliament and to the legislative of every state, and of elections to the offices of President and Vice President, held under this constitution shall be vested in a commission referred to in this constitution as the election commission. 2. The election commission shall consist of the chief election commissioner and such a number of the other election commissioner, if any, as the president may from time to time fix, and the appointment of the chief election commissioner and the election commissioner shall, subject to the provisions of any law made in that behalf by parliament, be made by the president. 3. When any other election commissioner is so appointed, the chief election commissioner shall act as the chairman of the election commission. 4. Before each general election to the House of the People and to the Legislative Assembly of each state, and before the first general election and thereafter before each biennial election to the Legislative Council of each state, having such council, the president may also appoint, after consultation with the election commission, such regional commissioner as he may consider necessary to assist the election commission in the performance of the functions conferred on the commission by the clause 1. 5. Subject to the provisions of any law made by the parliament, the condition of service and tenure of office of the election commissioner and the regional commissioners shall be such as the president may by rules determine. Provided that the chief election commissioner shall not be removed from his office except in like manner and on the like ground as the judge of the Supreme Court, and the condition of service of the chief election commissioner shall not be varied to his disadvantage after his appointment. Provided further that any other election commissioner or a regional commissioner shall not be removed from the office except on the recommendation of the chief election commissioner. 6. The president or the governor of a state shall, when so requested by the election commission, make available to the election commission or a regional commissioner such staff as may be necessary for the discharge of the functions conferred on the election commission by clause 1. Article 325. No person to be ineligible for inclusion in or to claim to be included in a special electoral roll on grounds of religion, race, caste or sex. There shall be one general election roll for every territorial constituency for election to either House of Parliament or to the House or either House of the Legislature of the state, and no person shall be ineligible for inclusion in any such roll or claim to be included in any special electoral roll for any such constituency on grounds only of religion, race, caste, sex or any of them. Article 326. Elections to the House of the People and to the Legislative Assemblies of State to be on the basis of adult suffrage. The elections to the House of the People and the Legislative Assembly of every state shall be on the basis of adult suffrage. That is to say, every person who is a citizen of India and who is not less than 18 years of age on such date as may be fixed in that behalf by or under any law made by the appropriate legislature and is not otherwise disqualified under this constitution or any law made by the appropriate legislature on the ground of non-residence in unsoundness of mind, crime, or corrupt or illegal practice shall be entitled to be registered as a voter at any such election. Article 327. Power of Parliament to make provisions with respect to election of two legislatures. Subject to the provisions of this constitution, Parliament may from time to time by law make provisions with respect to all matters relating to or in connection with election to either House of Parliament or the House of either House of Legislature of a state, including the preparation of electoral rolls, the delimitation of constituencies, and all other matters necessary for securing the due constitution of each house or houses. Article 328. Power of legislature of a state to make provisions with respect to elections to such legislature, subject to the provisions of the constitution and in so far as provisions in that behalf is not made by Parliament. The legislature of a state may from time to time by law make provisions with respect to all matters relating to or in connection with the elections to the House or either House of the legislatures of the state, including the preparation of electoral rules and all other matters necessary for securing the due constitution of such house or houses. Article 329. Bar to interference by courts in electoral matters. Notwithstanding anything in this constitution, a. The validity of any law relating to delimitation of the constituency or the allotment of seat to such constituency made or proportioning purporting to be made under Article 327 or Article 328 shall not be called in question in any court. B. No election to either House of Parliament or House of either House of the Legislature of a state shall be called in question except by an election petition presented in such authority and in such manner as may be provided for by or under any law made by the appropriate legislature. Article 329A. Special provisions as to elections of Parliament in the case of Prime Minister and Speaker. REP by the Constitution 44th Amendment Act 1978 Section 36 with effect from 20 June 1979. Part 16. Special provisions relating to certain classes. Article 330. Reservation of seat for scheduled caste and scheduled tribes in the House of the People. 1. Seats shall be reserved in the House of the People for A. the scheduled caste, B. the scheduled tribes except the scheduled tribes in the Autonomous District of Assam, and C. the scheduled tribes in the Autonomous Districts of Assam. 2. The number of seats reserved in any state or union territory for the scheduled caste or the scheduled type under clauses 1 shall bear as necessary as may be the same proportion to the total number of seats allotted to the state or the union territory in the house of the people as the population of the scheduled caste in the state of union territory or the scheduled tribes in the state of union territory or part of the state or the union territory as the case may be, in respect of which seats are so reserved bear to the total population of the state or union territory. 3. Notwithstanding anything contained in clause 2, the number of seats reserved in the house of the people or scheduled tribes in the autonomous districts of Assam shall bear to the total number of seats allotted to that state a proportion not less than the population of scheduled tribe in the said autonomous district bear to the total population of the state. Explanation. In this article and in article 332, the expression population means the population as ascertained at the last preceding census of which the relevant figures have been published, provided that the reference in the explanation to the last preceding census of which the relevant figures have been published shall, until the relevant figures for the first census taken after the year 2026 have been published, be construed as the reference to the 2001 census. Article 331, representation of the Anglo-Indian community in the House of the People. Notwithstanding anything in the Article 81, the President may, if he is of opinion that the Anglo-Indian community is not adequately represented in the House of the People, nominate not more than 2 members of the community to the House of the People. Article 332, reservation of seats for scheduled caste and scheduled tribes in the legislative assemblies of the state. 1. Seats shall be reserved for the scheduled caste and scheduled tribes except the scheduled tribes in the autonomous districts of Assam in legislative assembly of every state. 2. Seats shall be reserved also for the autonomous district in the legislative assembly of the state of Assam. 3. The number of seats reserved for the scheduled caste or the scheduled tribe in the legislative assembly of any state under clauses 1 shall bear as nearly as may be the same proportion to the total number of seats in the assembly as the population of scheduled caste in the state or of the scheduled tribe in the state or part of the state as the case may be, in respect of which seats are so reserved bears to the total population of the state. 3a. Notwithstanding anything contained in clause 3 until that taking effect under article 170 of the readjustment on the basis of the first census after the year 2026 of the number of seats in the legislative assembly of the states of Andhra Pradesh, Meghalaya, Mizoram and Nagaland, the seats which shall be reserved for scheduled tribes in legislative assembly of any such state shall be: A. If all the seats in legislative assembly of such state in existence on the date of coming into force of the Constitution 57th Amendment Act 1987, hereafter in this clause referred to as the existing amendment assembly, are held by the members of the scheduled tribes all the seats except one. B. In other cases, such a number of seats as bears to the total number of seats a proportion not less than the number as on the said date of members belonging to the scheduled tribe in the existing assembly bears to the total number of seats in the existing assembly. 3b. Notwithstanding anything contained in clause 3 until the readjustment under article 170 takes effect on the basis of the first census after the year 2026 of the number of seats in the legislative assembly of the state of Tripura, the seats which shall be reserved for the scheduled tribe in the legislative assembly shall be such number of seats as bears to the total number of seats, a proportion not less than the number as on the date of coming into force of the Constitution. 72nd Amendment Act 1992 of the members belonging to scheduled tribes in the Legislative Assembly in existence on the said date bears to the total number of seats in the Assembly. 4. The number of seats reserved for the autonomous district in the Legislative Assembly of the state of Assam shall bears to the total number of seats in the Assembly a proportion not less than the population of the districts bears to the total population of the state. 5. Constituencies. 5. The constituencies for the seats reserved for any autonomous district of Assam shall not comprise any area outside the district. Outside that district. 6. No person who is not a member of a scheduled tribe or any autonomous districts of the state of Assam shall be eligible for election in Legislative Assembly of the state from any constituency of that district, provided that for elections to the Legislative Assembly of the state of Assam, the representation of the scheduled tribes and non-scheduled tribes in the constituency, including in the Bodoland territorial areas district, so notified and existing prior to the Constitution, Bodoland territorial areas district shall be maintained. Article 333 Representation of the Anglo-Indian community in legislative assemblies of the states. Notwithstanding anything in Article 170, the governor of the state may, if he is of opinion that the Anglo-Indian community needs representation in the legislative assembly of the state and is not adequately represented therein, nominate one member of the community to the assembly. Article 334 Reservation of seats and special representation to cases after 70 years. Notwithstanding anything in the foregoing provisions of this part, the provisions of this constitution relating to a reservation of seats for the scheduled caste and scheduled tribes in the House of the People and in legislative assemblies of the state, and B. The representation of the Anglo-Indian community in the House of the People and in the legislative assembly of the state by nomination shall cease to have effect on the expiration of the period of 70 years from the commencement of this constitution, provided that nothing in this article shall affect any representation in the House of the People or in the Legislative Assembly of a state until the dissolution of the then existing House or Assembly, as the case may be. Article 335 Claims of scheduled caste and scheduled tribes to services and post. The claims of the members of the scheduled caste and scheduled tribes shall be taken into consideration consistently with the maintenance of efficiency of administration in the making of appointment to services and post in connection with the affairs of the union or of a state, provided that nothing in this article shall prevent in making of any provisions in favor of the members of the scheduled caste and scheduled tribes for relaxation in qualifying marks in any examination or lowering the standard of evaluation or reservation in matters of promotion to any class or classes of services or post in connection with the affairs of the union or of a state. Article 336 Special provisions for Anglo-Indian community in certain services. 1. During the first 2 years after the commencement of this constitution, appointment of members of the Anglo-Indian community to post in the railway, custom, postal and telegraph services of the union shall be made on the same basis as immediately before the 15th day of August 1947. During a succeeding period of 2 years, the number of posts reserved for the members of the said committee in the said services shall, as nearly as possible, be less by 10% than the numbers so reserved during the immediately preceding period of 2 years, provided that at the end of 10 years from the commencement of this constitution, all such reservations shall case 2 nothing in clause 1 shall bar the appointment of members of the Anglo-Indian community to post other than or in addition to those reserved for the community under that clause, if such members are found qualified for appointment on merit as compared with the members of other communities. Article 337 Special provisions with respect to educational grants for the benefit of Anglo-Indian community. During the first 3 financial year after the commencement of the constitution, the same grants, if any, shall be made by the union of each state for the benefit of Anglo-Indian community in respect of education as were made in the financial year ending on the 31st day of the March 1948. During every succeeding period of 3 years, the grants may be less by 10% than those of the immediately preceding period of 3 years, provided that at the end of the 10 years from the commencement of the constitution, such grants to the extent to which they are special concession to the Anglo-Indian community shall cease. Provided further that no educational institution shall be entitled to receive any grants under this article unless at least 40% of the annual admission therein are made available to the members of the communities other than the Anglo-Indian community. Article 338 National Commission for Scheduled Caste. There shall be a commission for the scheduled caste to be known as the National Commission for Scheduled Caste. 2. Subject to the provisions of any law made in this behalf by Parliament, the commission shall consist of a chairperson, vice chairperson and 3 other members, and the condition of services and tenure of office of the chairperson, vice chairperson and other members so appointed shall be such as the President may by rule determine. 3. The chairperson, vice chairperson and other members of the commission shall be appointed by the President by warrant under his hand and seal. 4. The commission shall have the power to regulate its own procedure. 5. It shall be the duty of commission A. To investigate and monitor all matters relating to the safeguards provided for the scheduled caste under this constitution or under any other law for the time being in force or under any other order of the government, and evaluate the working of such safeguards. B. To continue to inquire into specific complaints with respect to the deprivation of rights and safeguards of the scheduled caste. C. To participate and advise on the planning process of socio-economic development of the scheduled caste and to evaluate the progress to their development under the union and any state. D. To present to the President annually and at such other times as the Commission may deem fit reports upon the working of these safeguards. E. To make such reports recommendations as to the measures that should be taken by the Union or State for the effective implementation of those safeguards and other measures for the protection, welfare and socio-economic development of the scheduled caste, and F. To discharge such other functions in relation to the protection, welfare and development and advancement of scheduled caste as the President may, subject to the provisions of any law made by Parliament by rule specify. 6. The President shall cause all such reports to be laid before each House of Parliament along with a memorandum explaining the action taken or proposed to be taken on the recommendations relating to the Union and the regions for the non-acceptance in any of such recommendations. 7. Where any such reports or any part thereof relates to any matters with which any state government is concerned, a copy of such reports shall be forwarded to the governor of the state, who shall cause it to be laid before the legislature of the state along with the memorandum explaining to the action taken or proposed to be taken on the recommendation relating to the state and the regions for the non-acceptance, if any of such recommendations. 8. The Commission shall, while investigating any matter referred to in subclauses A or inquiring into any complaint referred to in subclauses B of clauses 5 have all the powers of civil courts trying a suit, and in particular in respect of the following matters, namely: A. Summoning and enforcing the attendance of any person from any part of India and examining him on oath. B. Requiring the discovery and production of any document. C. Receiving evidence on affidavits. D. Requisitioning any public record or copy thereof from any court or office. E. Issuing commission for the examination of witness and documents. F. Any other matters which the President may by rule determine. 9. The Union and every state government shall consult the Commission on all major policy matters affecting scheduled castes. 10. In this article, reference to the scheduled caste shall be construed as including reference to the such other backward classes as a President may, on receipt of the report of a commission appointed under clauses 1 of the article 340 by order specified, and also to the Anglo-Indian community. Article 338A, National Commission for Scheduled Tribes. 1. There shall be a commission for the scheduled tribes to be known as the National Commission for Scheduled Tribes. 2. Subject to the provisions of any law made in this behalf by Parliament, the Commission shall consist of a chairperson, vice chairperson, and 3 other members, and the condition of service and tenure of office of the chairperson, vice chairperson, and other members so appointed shall be such as the President may by rules determine. 3. The chairperson, vice chairperson, and other members of the commission shall be appointed by the President by warrant under his hand and seal. 4. The commission shall have the power to regulate its own procedure. 5. It shall be the duty of the commission: A. To investigate and monitor all matters relating to the safeguards provided for the scheduled tribes under the Constitution or under any other law for the time being in force, or under any order of the government, and evaluate the working of such safeguards. B. To inquire into specific complaints with respect to the deprivation of rights and safeguards of the scheduled tribes. C. To participate and advise on the planning process of socio-economic development of the scheduled tribes, and to evaluate the progress of their development under the Union and any state. D. To present to the President annually and at such other times as the Commission may deem fit reports upon the working of those safeguards. E. To make in such reports recommendation as to the measures that should be taken by the Union or any state for the effective implementation of those safeguards and other measures for the protection, welfare, and socio-economic development of the scheduled tribes. And F. To discharge such other functions in relation to the protection, welfare and development and advancement of the scheduled tribes as the President may, subject to the provisions of any law made by Parliament by rules specify. 6. The President shall cause all such reports to be laid before each House of Parliament along with a memorandum explaining the action taken or proposed to be taken on the recommendation relating to the Union and the regions for the non-acceptance, if any, of any such recommendations. 7. Where any such reports or any part thereof relates to any matter with which any state government is concerned, a copy of such reports shall be forwarded to governor of the state, who shall cause it to be laid before the legislature of the state along with memorandum explaining the action taken or proposed to be taken on the recommendation relating to the state and the regions for the non-acceptance, if any, of such recommendation. 8. The Commission shall, while investigating any matter referred to in subclauses A or inquiring into any complaint referred to in subclauses B or clauses 5, have all the powers of civil courts trying a suit and in particular in respect of the following matters, namely summoning and enforcing the attendance of any person from any part of India and examining him on oath. B. Requiring the discovery and production of any document. C. Receiving evidence on affidavits. D. Requisitioning any public record or copy thereof from any court or office. E. Issuing summons for the examination of witness and documents. F. Any other matter which the President may by rules determine. 9. The Union and the every state government shall consult the Commission on all major policy matters affecting scheduled tribes. Article 339. Control of the Union over the administration of scheduled areas and the welfare of scheduled tribes. 1. The President may at any time and shall at the expiration of 10 years from the commencement of this Constitution by order appointed a commission to report on the administration of the scheduled areas and the welfare of the scheduled tribes in the states. The order may define the composition, power and procedure of the commission and may contain such incidental or ancillary provisions as the President may consider necessary or desirable. 2. The executive power of the Union shall extend to the giving of directions to the state as to the drawing up and executing of schemes specified in the direction to be essential for the welfare of the scheduled tribes in the state. Article 340. Appointment of a commission to investigate the condition of backward classes. The President may by order appoint a commission consisting of such person as he thinks fit to investigate the condition of socially or educationally backward classes within the territory of India and the difficulties under which they labor, and to make recommendation as the steps that should be taken by the Union or any state to remove such difficulties and to impose their condition, and as to the grants that should be made for the purpose by the union or state, and the conditions subject to which such grants should be made, and the order appointing such commission shall define the procedure to be followed by the commission. 2. The commission so appointed shall investigate the matter referred to them and present to the President a report setting out the facts as found by them and making such recommendations as they think proper. 3. The President shall cause a copy of the report so presented together with a memorandum explaining the action taken thereon to be laid before such House of Parliament. Article 341, Scheduled Caste. 1. The President may, with respect to any state or union territory, and where it is a state, after consultation with the governor thereof, by public notification, specify the caste, races or tribes or parts of groups within caste, races or tribes which shall be for the purpose of this constitution be deemed to be scheduled caste in relation to the state or union territory as the case may be. 2. Parliament may by law include in or include from the list of scheduled caste specified in notification issued under clause 1 any caste, race or tribes or parts or a group within any caste, race or tribe, but save as aforesaid, a notification issued under the said clause shall not be varied by any subsequent notification. Article 342, Scheduled Tribes. 1. The President may, with respect to any state or union territory, and where it is a state, after consultation with the governor thereof, by the public notification specify the tribes or tribunal communities or parts of or a group within the tribes or tribal communities which shall for the purpose of this constitution be deemed to be scheduled tribes in relation to the state of union territory as the case may be. 2. Parliament may by law include in or exclude from the list of scheduled tribes specified in notification issued under clause 1 any tribe or tribal community or part or group within any tribe or tribal community, but save as aforesaid, a notification issued under the said clause shall not be varied by any subsequent notification. The Constitution of India, Part 17, Official Language, Chapter 1, Language of the Union, Article 343, Official Language of the Union. 1. The official language of the Union shall be Hindi in Devanagari script. The form of number to be used for the official purpose of the Union shall be international form of Indian numbers. 2. Notwithstanding anything in clause 1, for the period of 15 years from the commencement of this constitution, the English language shall continue to be used for all of its official purpose of the Union for which it was being used immediately before such commencement, provided that the President may during the said period by order authorize to use of the Hindi language in addition to English language and the Devanagari form of numbers in addition to the international form of Indian numbers for any of the official purpose of the Union. 3. notwithstanding anything in this article, Parliament may by law provide for the use after the set period of 15 years of A. the English language, or the B. the Devanagari form of numerals, for such purpose as may be specified in the law. Article 344, Commission and Committee of Parliament and Official Language. 1. The President shall, at the expiration of 5 years from the commencement of this Constitution, and thereafter at the expiration of 10 years from such commencement, by order constitute a commission which shall consist of a chairman and such other members representing the different languages specified in English scheduled as the President may appoint, and the order shall be defined the procedure to be followed by the Commission. 2. It shall be the duty of the Commission to make recommendation to the President as to A. the progressive use of the Hindi language for the official purpose of the Union. B. Restriction on the use of English language for all or any of the official purpose of the Union. C. The language to be used for all or any of the purpose mentioned in Article 348. D. The form of numeral to be used for any one or more specified purpose of the Union. E. Any other matters referred to the Commission by the President as regards to the official language of the Union and the language for communication between the Union and the state, or between one state to another, and their use. 3. In making their recommendation under clause 2, the Commission shall have due regards to the industrial, cultural and scientific advancement of India, and just claim and interest of persons belonging to the non-Hindi speaking areas in regards to the public services. 4. There shall be constituted a committee consisting of 30 members, of whom 20 shall be members of the House of the People and 10 shall be members of the Council of State, to be elected respectively by the members of the House of the People and the members of the Council of States in accordance with the system of proportional representation by means of the single transferable vote. 5. It shall be the duty of the committee to examine the recommendation of the Commission constituted under clause 1 and the reports to the President their opinion thereon. 6. Notwithstanding anything in Article 343, the President may, after consideration of the report referred to in clause 5, issue direction in accordance with the whole or any part of the report. Chapter 3, Regional Languages. Chapter 2, Regional Languages. Article 345, Official Language or Languages of a State. Subject to the provisions of Article 346 and 347, the legislature of a state may by law adopt any one of or more of the languages in use in the state, or Hindi as the language or languages to be used for all or any of the official purpose of the state. provided that until the legislature of the state otherwise provided by a law, English language shall continue to be used for the official purpose within the state or which it was being used immediately before the commencement of this constitution. Article 346 official language for the communication between one state and another or between a state and the union. The language for the time being authorized for use of the union for official purpose shall be the official language for communication between one state and another state and between a state and the union, provided that if two or more states agree that the Hindi language should be the official language for communication between such other state, the language may be used for such communication. Article 347 special provisions relating to language spoken by a section of the population of a state. On the demand being made in that behalf, the President may, if he is satisfied that the substantial proportion of the population of state desire to use of any language spoken by them to be recognized by that state, direct that such language shall also be officially recognized throughout the state or any part thereof of such purpose as he may specify.